Today we're continuing on that analogy of using a fence to protect one's financial assets. And this fence is a trust. There are a lot of different trusts, and two of them that we'll talk about today are irrevocable trusts and supplemental needs, or sometimes called special needs trusts. The keys here are we've got to be very, very careful about some of the rules, and we cede some control for the benefits that we receive. So we'll go ahead and dive in.
All right, so Spencer, today we're going to be talking about irrevocable and special needs or supplemental needs trusts. And those kind of categories are broad and they're varied, but we really want to hone in on what are the situations that our clients could most often face. So when we think about an irrevocable trust, what are just the basics of an irrevocable trust?
Well, we've been building off of that analogy of a trust as like a fence for our financial assets. And in that way, if we think about that fence, and there's not always a need to build a fence first. So we really have to diagnose and say, is there a need that we build this fence? Because it's expensive and it's more cumbersome to get into and out of that gated area. Now, with an irrevocable trust, we're basically handing over the key to the lock and gate system there to somebody else. So we're ceding a lot of control there. A revocable trust, we set everything up, but we retain the key, and to the point that we even have all of those assets still filed under our own tax return. So a revocable trust oftentimes is just used for moving assets instead of through probate at the end of life, being able to move them into a trust and deal with them maybe more seamlessly, particularly in some states. But an irrevocable trust, before we pass away, we are giving up those assets. We are assigning those assets to that trust. And there's some different pieces to that. Now, we do want to make the note here that if you have a revocable trust and you pass away, then that's going to trigger it to become an irrevocable trust. So at that point, a new trustee is put in place and it's set up with its own tax identification number, all those kinds of different pieces that actually make it irrevocable. But this is a different thing that we'll be talking about, which is an irrevocable trust maybe from day one, where we're actually putting assets there because of some of the characteristics of that irrevocable trust.
Yeah. So let's start off with the parties. Who all is involved in an irrevocable trust?
So you've got a grantor, one or more grantors that are actually putting the funds into the trust. They're setting up the trust and typically funding the trust. They aren't always the only people funding the trust, but usually they're the ones that are contributing a substantial amount of the assets to the trust. Of course, then we have a trustee, and this is where things start to diverge from the revocable trust, because a revocable trust, typically the grantor starts out being the trustee as well. In an irrevocable trust, if you fund it, then you're naming someone else, and that could be a person or it could be a corporate trustee that is managing the trust. So it's that person or that corporate trustee is looking after the trust in terms of the provisions in the trust document there. So that's the trustee, and then the third party is the beneficiary. So beneficiary is going to be the one that's going to receive the funds from the trust, receive the benefits from the trust. So most of the time, as we look at an irrevocable trust, the beneficiary and the grantor will not be the same. But there have been new trust laws that have been drafted in places like Tennessee and others. There's plenty of other states around the country, Nevada, Alaska, and others, where you have a trust that's actually set up and funded by the grantor, but the grantor is also the beneficiary. There's a whole lot of different pieces to that, and it's basically built off of trying to get creditor protection. There's a lot of hoops that you've got to jump through. It's not something that we do a whole lot for clients with, but it is out there, and we recognize that it's becoming more and more popular. Now, the flip side of that is that the courts have not decided how much they're going to honor some of those new laws. This is one way that wealthy people can kind of defend their resources against creditors or against claimants. And so there's still a lot of attorneys that are saying, how far can this go in terms of being able to provide that protection? Because the laws that have been drafted in these different states, and many of them, they're fairly new.
That's good to know. And one thing to know about a trustee is they have a fiduciary responsibility. So you just want to run through what that means.
Yeah, so the trustee has to act in accordance with the language within the trust. So if you have a person that you name, let's say a family member or a friend that you're naming, then they're supposed to abide by the provisions within the trust. Particularly if you have a corporate trustee. So if you name someone that this is what they do for a living, then they're going to very, very tightly hold to that language, and they're going to be held to that standard at a professional level, perhaps even higher than what we would find just a normal fiduciary level for a commoner, so to speak, or a lay person. So that person has always got to act within the provisions of what's laid out in the trust, and they're held to a very high standard by law to do so.
Yeah, so it seems like it's a really important person to think about who is going to be that trustee, especially if I'm relinquishing all of my control into that trust.
Yes.
Okay, so you've kind of laid out some of them, but what are some key differences between a revocable and irrevocable trust?
Well, one of the things that we have to remember, typically an irrevocable trust is set up for one of a couple different reasons. You may be in a situation where you're in a high-risk profession. You're a surgeon, or you run a business where there might be creditors coming after you, or things could go sideways, and you want to be able to protect some assets and pass them on maybe to the next generation or generations. In that circumstance, you may want to set up an irrevocable trust and assign those assets to that trust, obviously when you're not under investigation or you don't have a lawsuit already against you, because if those are the conditions actually that you fund the trust, then there's a high likelihood that the claimant is going to be able to come after you, and the creditor can come after you in that circumstance oftentimes. So you want to set up an irrevocable trust when everything is good, is hunky-dory, and you're assigning those assets into the trust and you're relinquishing control again. And so if something bad does happen to you down the road, then those assets typically, they're not going to be able to be touched by that creditor. So we oftentimes would see a physician do this, again, or a business owner do this. Another place that we might see someone do it is if they're really looking at estate tax and they're very concerned about that. Let's just say that we come up here to 2026 and we see that the estate tax exemption is going to be cut down substantially. We might see clients move resources over into an irrevocable trust, go ahead and fund that so that they can fill up their lifetime exemption amount there, the gift and estate exemption there prior to the change in 2026 where that amount is going to be halved. So in doing that, they get it out of their estate. Now, it's still counted as a gift against them if they go above that annual gift limit. But if they get it out of their estate, then any assets that grow from there in that irrevocable trust are not going to be counted back into their estate if they do things properly.
So what are some of the disadvantages of an irrevocable trust?
Well, we've talked about it. You're ceding control. That is the biggest one. And in ceding control, there's all kinds of other ramifications. So one of them is you've got to set up a tax ID and you've got to pay taxes for the assets in that trust. So taxes for trust assets are oftentimes not advantageous to you. The trust tax brackets are compressed compared to individual tax brackets. So there are ways to manage around that. But oftentimes, trust assets are just taxed at a higher level, even if you do a nice job managing it. When you cede control, there's other pieces to that sometimes can make things just difficult. You cede control. Well, what if things come up that you really didn't need that creditor protection, or you retired as a surgeon and you'd like to be able to pass those assets unencumbered on to your daughters or sons, there. Then things that come up, now you have challenges in updating that irrevocable trust. So it can be done in many states. In the state of Tennessee, we're fortunate that even irrevocable trusts, oftentimes, they can be modified or they can be terminated if we have consent from all the parties involved. So that typically would look like all of the grantors, all of any trustee, and then any beneficiary. So that's a high bar, because if you have, say, two grantors and one passes away, okay, now we've got to move through the courts typically. So we want to be careful as we set this up to say once we do it, it's tough to be able to modify it or dissolve it. for good reasons.
Well, and like you mentioned earlier, trusts are not easy to establish. Just like building a fence, the bigger your property is, the more expensive the fence is going to cost. So when we think about creating an irrevocable trust, it's not just complex because of all the different nuance, but it's complex and it's expensive to set up. So you really have to be considerate of, is this the direction that you want to head?
Right. You're going to want to work with an attorney who is a specialist in this area. You're going to be paying them probably several $1,000s, if not, even $10,000 to set up the trust. There may be costs in funding the trust or retitling assets to move them to a trust. So there's lots of different considerations in there. And then you've got all of the tax pieces that we talked about. As well, if you use a corporate trustee, which many people do, there's a whole nother layer of fees. And so you oftentimes would expect that somewhere between 0.5% and 1% of the assets on an annual basis are going to be paid towards the management of that corporate trustee.
Okay, so Spencer, we've walked through irrevocable trust. Let's talk about special needs or supplemental needs trust. Can you just give us a brief overview of what those are?
So these are trusts that are set up oftentimes when we have a family member or a close friend that we know over the course of their lifetime they're probably not going to be able to manage money. And that oftentimes would be from some disability that is expected to just persist over the course of their lifetime. So a supplemental needs trust oftentimes is drafted with this individual in mind, and it's drafted with the idea that we don't want to take away any benefits that they might receive from the state or from the federal government. So there are benefits, of course, whether it's via Social Security or other programs that a person can tap into. There's also healthcare in various states that can be helpful to be able to have access to, that one can qualify for in certain circumstances, but some of those are means tested. So with the supplemental needs trust, what we're trying to do is draft it in such a way that as assets go in, we have a trustee who is understanding of these different ground rules and can enhance the beneficiary's life by paying for certain things, but not for other things that would take away the benefits. Mm-hmm. So for instance, in many states and many places, if you're paying for housing, then you're violating different provisions, and the beneficiary may not have access to state-funded health care. Well, that can be a huge detriment. It can be tens of thousands of dollars of benefit that they could receive otherwise. So we want to make sure that the document is drafted well, that it allows the trustee to do the things that the trustee needs to do to make sure that things that are paid for are not going to violate some of those public benefits that are out there. So this is one where, oftentimes you'd say, well, if you have an attorney who you've worked with, that you're comfortable with, who's a generalist, perhaps they can draft a will or power of attorney. This is one of those areas that you need a specialist, because these laws move around a lot and they're different state to state, and there is a high level of complexity. We don't want to stub our toe on any of these pieces because the outcome can be really, really nasty in losing some of those benefits, not just for a short period of time, but even for a much longer period of time for these beneficiaries.
Right, absolutely. So we've talked about some of the advantages of these special needs trusts. Things like continuation of benefits, things like the flexibility of assets that you can put in and the range of benefits for that beneficiary. We've talked about just the long-term planning. If you've got someone that has a disability, they're going to need long-term planning probably after you pass. So what are some of the disadvantages?
Well, we really have to think about where the beneficiary is at in his or her life and what they may be facing. So if we're in a situation where they haven't qualified for public benefits, we're not sure how a ruling may come out, whether they may be within some of the ground rules, they may qualify for benefits, then we want to make sure that if we jump through all of the hoops to set up a supplemental needs trust, that it's actually going to benefit them. So if they didn't qualify for any of those public benefits, we'd say, well, why use a supplemental needs trust? Perhaps because there are lots of different pieces to that would need to be added. I mean, some of these trusts you'll see, they might be 60 pages in length because of all the different things that would need to be considered. much easier to just draft a simple trust that wouldn't have all of this, language that might be more of a spendthrift type of trust, where we still have a trustee in place who is managing distributions and helping that person over time, but doesn't have all of the different supplemental needs language that's in there.
So Spencer, we're going to ask a couple of the frequently asked questions that we either receive from clients or that we see often posed online. And so one of them has to do with this idea of putting a home into an irrevocable trust to avoid Medicaid estate recovery. And essentially this is saying you're foreseeing that there's a potential for long-term care. Either there's memory decline or some other event in the future where you're foreseeing this could happen. And you want to put your house into that trust. Is that going to protect it from Medicaid estate recovery?
So it's a really complex question. Every state is a little bit different. Every attorney, even within states, is going to have a little different perspective on this. Our perspective on this is, first, as people reach out to us, there's this fear that if a client goes into long-term care, they're going to lose everything. And what actually happens if you move into long-term care, let's say you go into assisted living or a nursing home, you're paying for that over time. So in our area, maybe you're paying $90,000 a year in 2023 for nursing home care. If you have $1 million, you're probably not going to see those assets run out unless you're in a nursing home for a very, very long time. An average stay might be, a year and a half or something like that. So we want to recognize that first, just because you go into a nursing home doesn't mean that you surrender all of those assets. But part of the fear is, mom, dad, maybe they don't have a whole lot of assets, but they have their home. And so what we'd like to do is put in the home into an irrevocable trust so that if they need long-term care, the state can't take the home. We want to pass that on to the family. And, we understand, why people want to go in this path. And there are some attorneys that will draft irrevocable trusts. The home will be retitled, and they know that they've got to take care of expenses for at least 5 years, or there's, a look back, in that. And it may work. What we've been told by different attorneys, though, is that the courts haven't fully ruled on this. The state doesn't like the fact that you're trying to protect these assets in a lot of different ways. Now, there's some states that actually encourage you to buy insurance, and they kind of work with you to make sure that if you have that insurance, that they're not going to come after your other assets. In a lot of places, though, like Tennessee, we have a level of uncertainty that a trust like that would actually hold up in court if it was pressed by what our attorney professionals who we're colleagues with have told us. So a lot of different opinions on that, but I'd certainly think hard before you start to create an irrevocable trust, put the home there, and work with a really good attorney on that.
All right, so the next two questions are going to get a little bit easier.
Okay.
The next one, can you sell a house that's in an irrevocable trust?
Well, that's up to the trustee. So the house can be sold, but oftentimes what happens, again, if we walk back and we say, okay, we have a revocable trust that's set up during someone's lifetime. That revocable trust holds their home. They pass away. That becomes an irrevocable trust. So that trustee then steps in, that new trustee steps in, and oftentimes the provisions within a trust will say, well, I want the home sold, and then I want the proceeds distributed evenly to a handful of different beneficiaries. So the trustee would act if that was the language within the trust. The trustee would say, okay, the intention is that the home is sold. In other situations, the home might be said the intention might be to hold the home, therefore one of the beneficiaries, and have other beneficiaries get other things. So all kinds of different ways that you can go about that, but you can have the trustee for an irrevocable trust sell a piece of property, whether it be a home or a second home or a tract of land.
You've compelled me that I should put together an irrevocable trust.
Oh,
Can
gosh.
I just go write this down on a piece of paper and make it myself?
Let it not be so. You need to work, again, with an attorney. We are not attorneys. We cannot draft those documents. And particularly with irrevocable and supplemental needs trusts, we think it's critical that you work with a specialist on this. Every state is going to have different laws. And if you live in one state, but you have piece of land in another state, why, you've even got more complexity. So you certainly need a competent professional draft these, walk everything through with you, and then work with them and your financial advisor to make sure that you title all of the property in the appropriate way and get the beneficiary designation set up appropriately too, because you can spend tens of thousands of dollars on a trust and it not help you if you don't follow through and actually implement the different pieces necessary.
Spencer, thanks for walking us through all of those details of irrevocable and special needs trusts. It's complex. There's a lot going on. We hope you enjoyed this video. Again, we are not estate planning attorneys. We cannot draft these documents. We can listen to you. We can hear your questions. Clients, if you want to bring in any of those questions about trust to us, we would love to talk to you about it. But until next time, we hope you enjoyed this video and we'll see you soon. If you like these financial planning videos, please share it with a friend. And if you have questions, go to our website at seriousretirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at seriousretirement.com. The information in this recording is intended for general educational and informational purposes only and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.